Thank you. My name is Alan Marco. I'm the Chief Economist at the U.S. Patent and Trademark Office. You can tell that I'm an economist because I'm the one guy in the room not wearing a tie. Maybe it was a few of us. I presume you're also economists. What I want to talk about today is what I'm titling Patent Litigation, USPTO Trials, Implications for Patent Quality. I'm not going to be talking about all of those topics. I'm entitling it that because that's the title of a recent report that my office completed along with a couple other offices. There was a joint project team within the Patent and Trademark Office. Although my remarks will be restricted specifically to the part of the study that my office conducted. So this was actually the study that I'll be discussing here was really done on the basis of a recommendation by the GAO. So some of you may be familiar with that report back in 2013 where the GAO did a study about patent litigation. They were specifically looking at non-practicing entities. And in that, the GAO recommended that the PTO consider investigating trends in patent infringement litigation, basically to see whether there was anything that we could infer from litigation that would help us say something about patent examination or patent quality. We took that recommendation and we conducted that study and also expanded the analysis to include IPR petitions. So the report was completed in January 2015. It's on the website, the PTO website under the Office of Chief Economist, so you can find it there under our publications. What I want to do is walk through kind of our way of thinking about the study and the purpose of it, and then some of the results. But again, I'll restrict the results to the part that my office was involved with. So why focus on litigated and petitioned patents? Well, to think about why patents would go forward from an economic standpoint, go forward into litigation, you have at least, there's a lot in the literature about this, but there's at least two hurdles that you need to get over. First of all, the patent would need to be valuable enough to warrant some sort of dispute, to be involved in some sort of dispute, that you'd be willing to invest the costs in going forward to litigation. We think there has to be some amount of uncertainty, right? If you're absolutely certain about what's going to happen at trial, well, you'd probably settle before you ever got to the too far into the dispute. And it's unfortunately quite difficult to separate these two things. When we see higher incidences of litigation, we don't know if that's because the patents are more valuable or because there's more uncertainty. But this is at least a first cut at trying to disentangle some of those things. We think there's it probably raises more questions than it answers, which is typical of a lot of empirical work, especially in litigation. But we think that it raises some important questions. So we also, in the report, it also involved a detailed analysis of really the first written decisions by the PTAB when we had a set of specialized examiners who went back and sort of looked at the patent prosecution record as it relates to what the board found to try to make some inferences. It's a very small sample because we were really looking at the first stages of those, the first written decisions. But there are again, some interesting questions that come out of that. I encourage you to take a look at the report, but I won't be commenting specifically on that part of it today. So our data sources, I'll spend just a little bit of time on the litigation side. We did just go ahead and use the data that the GAO used in their report. So we thought, well, the GAO is making this recommendation. Let's start with their sample, which they got from Lex Machina, and which Lex Machina was willing to share with us as well. So this is a random sample of 500 lawsuits filed between 2007 and 2011, so 100 per year, 500 cases. Those involved 990 patents. In those lawsuits in terms of patents in suit, which represents 4% of those that are in Lex Machina's database for that period. So we took, for this study, the incidence of first litigation. So if a patent was litigated twice, we just looked at the fact that the first time it's litigated, let's just call that it's a litigated patent. And we're just looking at filings at this point, so we didn't look at outcomes. If we try to look at outcomes, obviously our sample size gets quite small quite quickly. Similarly with IPR petitions, we took all of the IPR petitions filed between September 2012 to July 2014. So we were able to use all of those petitions. Here we're focused mainly on, again, the incidence of first petitions. So there were 1,500 petitions covering 1,000 unique patents. We looked at, what are the factors that contribute to or that can be used as explanatory variables for whether a patent is involved in an IPR. Okay, so in looking at this sample size, you might think, well, a lot of the IPRs come from out of first a litigated case, so won't you really find the same results? Possibly, except, so in our case, what we did is we looked at these IPR petitions over this time period. We took the larger set of all patents that we could identify as being litigated from 1 year before to July 2014, and we asked the question, so for how many of these IPR petitions was there a filed litigation within 12 months before the IPR was petitioned? So if you look at in the red circle, right, that's looking at the percentages as a proportion or as a percentage of the total number of IPR petition patents. We have 1,069 patents. 61% of them had a case filed in district court in the previous 12 months. So that's a large majority of the IPR petition patents. However, that represents a small minority of the overall number of litigated cases. 94% were not involved in IPR within 12 months after filing. 6% were. So yes, the IPR petition cases are going to look like a subset of the litigated cases, but it's not at all clear that it's going to be representative of all litigated cases. So we still want to investigate these separately and see whether there are different factors that explain whether they end up in litigation or as the subject of an IPR petition. So our method is one that's fairly common in the economics literature. We look at a control group of non-litigated and or non-petitioned patents that we try to match with those that we know are litigated or petitioned. So we want to match on things that we think make them somewhat similar, except for the fact that they were litigated, and then go back and say, well, what characteristics are then correlated with being in the litigated or non-litigated groups, or the petitioned or non-petitioned groups. So we try to keep them somewhat similar, but the more things that you match on, the more similar you get in terms of what you match on, the less you can sort of investigate as to what explains the litigation. So there's this trade-off that's involved, and we tried a few different methods. I'm going to just talk about the one set of results here, and we use a method. It's a type of a regression analysis called conditional logit. We're really just asking, is the odds of litigation or IPR petition correlated with these explanatory variables that we have that I'll mention in just a moment. So again, the odds is just really the probability of litigation over 1 minus the probability of litigation. So a 90% probability of litigation would be 9 to 1 odds. So that it turns out that looking at the odds is just sort of an easier way to estimate this model. As I said, we have a few different ways of doing the matching. We've tried a few different things. This is the one that I'll be talking about today. So our matching variables, we match on the grant year. We want to make sure these things are issued in the same year. The examination work group, so that it's coming from a relatively similar area, but not necessarily identical. Once we try to get an identical technology, our control group gets whittled down pretty quickly. So we need to make it broad enough that we can have enough choice to select a random control patent. We also match on maintenance history. So even though that's post-grant, we want to be sure that this is an attempt to try to match on value in part, right? So we want to make sure that we didn't pick one that was never maintained, therefore it couldn't possibly have been litigated, after a certain period of time. So it matches with the maintenance history of the litigated or petitioned case, and the number of forward citations. We do kind of a fuzzy match there, nearest neighbor, as we call it. So those are attempts to get something that looks relatively similar. And then let's investigate these other application characteristics, prosecution characteristics, and claims characteristics to see whether they have any explanatory power in whether a patent is litigated or goes to IPR petition. So these application characteristics, a lot of things that are used already in the literature: small entity status, foreign priority, PCT parent, so national stage entry of a PCT application, the number of U.S. Domestic parent applications in family, and the total pendency of the entire family of U.S. patents. What we're adding to this over and above the other literature in economics is that we're looking at some prosecution characteristics and claims characteristics. The GS level of the examiner, number of RCEs, whether it was involved in an appeal, the examination pendency, so the pendency before the examiner, the active sort of pendency at the office, number of information disclosure statements, number of interviews, first action allowance, right? So these are things that we can relatively easily codify from our internal systems. We rejected looking at some things that would be really great to look at, but would be very time consuming and take a lot of hand coding. So as our first pass, this was what we decided on. Claims characteristics, we looked at the independent claim count, the independent claim length. By independent claim length, I'm talking about the shortest, so what is the number of words in the shortest independent claim, being a rough proxy for more words being expected to be correlated with a narrower claim, and whether the independent claims contain some functional claim language defined. We define that better in more detail in the paper. So our main results are that the incidence of IPRs in litigation are impacted by characteristics of examination, but the largest impacts are those that come from non-examination characteristics. So I'll show you a picture in the next slide, and then I'll be, I think, right on time. And then secondly, that IPRs, the profile of IPRs and litigation, IPR petition patents and litigated patents tends to look the same in terms of the characteristics that explain their involvement in either the incidence of either litigation or IPR petition. So basically the same characteristics explain litigation and IPR petition in about the same way. So this is the one graph that I'll try to demonstrate the results here and see if that works, trying to combine this all into one graph. So we have here on the left-hand side, what we're looking at is the percentage change in the odds of filing, either being involved in a filed litigation or an IPR petition. And on the bottom is just all the different characteristics that we use to try to explain that. Anything at the 0 line tells us that there's no real significant change based on this variable. So for instance, being involved in an appeal, while its point estimate is above the line, right, since the bars, our error bounds, cross over the line, it's not statistically significant. So we want to focus on those that are statistically significant. On the far left, small entity status, right? If you're a small entity, you're more likely to be involved in both litigation and IPR petition. On the far right, foreign priority, you're less likely to be involved in both litigation and IPR petition. So you can see that the pattern of these, of the magnitudes really track between litigation and IPR petition. So that's one of the results of what I mentioned. And secondly, these examination characteristics, things like the interview count or the IDS count, the independent claim count, RCEs, et cetera. These things in the middle tend to be these examination characteristics. Some of them are significant, some of them are not. But their magnitudes are much smaller than these other kind of just main things that we know actually from the previous economic literature that are important: small entity status, foreign priority, the number of previous parent applications, et cetera. So there's more of these that I could discuss in detail if I had more time, but in the interest of time, I'll stop my remarks there and allow the discussants to talk about that. So thank you.